you very much. My name is Gemma Morgan. I'm a barrister at Quadrant Chambers and I specialise in commercial law. And over the next 10 minutes, I'm going to answer for you the enticing question of what is force majeure. It's a French expression which literally means irresistible force, and it's used in a contractual context to describe a supervening event which prevents or hinders performance of the contract. Now, contractual parties use a force majeure clause to identify circumstances in which one or either party may be excused performance, either for the period during which the event occurs or permanently. Now, it's important to say at the outset that force majeure is a very different beast from frustration. Frustration is a common law doctrine which may apply to end the contract where an unforeseen event occurs after the contract is entered into, which is outside the control of the parties and makes the contract either physically or commercially impossible or illegal to perform. It is applied very narrowly by the courts, who are reluctant to interfere with the parties' bargain. Force majeure, by contrast, is the parties agreeing in advance circumstances in which they may be excused performance. What's the test for force majeure? Well, it's always going to depend upon the precise words of the contract, and that's the first place you need to look. You'll see phrases in a force majeure clause such as performance has been delayed or temporarily prevented, event beyond the control of the party, or parties shall use their reasonable endeavours to overcome the circumstances of force majeure. But for a typical clause, a party seeking to rely on force majeure will normally have to show four things. So, first, a force majeure event. Second, that performance has been prevented, hindered or delayed. Thirdly, that non-performance is due to circumstances beyond his control. And fourthly, that there are no reasonable steps he could have taken to avoid or mitigate the force majeure event or its consequences. Remember that the burden of proof is always on the party asserting force majeure. So, dealing with the first limb of the test, what is a force majeure event? Classic examples are war, flood, strike, storm, fire, act of God, pandemic, but it can be anything that the parties specify that relates to the contract in question. So, for example, an embargo on particular exports for a sale contract. It's well established that an economic change, such as a market downturn or a financial crash, cannot amount to force majeure. So a contract becoming more expensive or even prohibitively expensive to perform cannot be force majeure. This does not get parties out of a bad bargain. Now, secondly, it has to be the case that the force majeure event caused the inability to perform. Depending upon the wording of the clause, something that hinders or even delays performance rather than prevents it outright might be enough. Where the word prevention is used, performance must become physically or legally impossible. But where hinder is used, performance must only become substantially more onerous. The test for causation has been really helpfully summarised by the courts like this. Questions of causation are sensitive to the legal context in which the question arises. They are to be resolved by reference to common sense and be determined by a broad, common sense view of the whole position. So, it's no good simply saying, well, there's a global pandemic and that means I can't make and deliver the shoes you ordered. Sorry. You have to be specific. You have to show why the pandemic meant that your supply chain was interrupted. You have to show that you couldn't get the raw materials you needed to make the shoes. You have to prove that your staff weren't allowed to come to work and make the shoes by reason of a government order. Now, something that crops up not uncommonly is having two effective causes of the inability to perform. It's always a matter of construction of the contract, but usually the force majeure event has to be the sole effective cause of the inability to perform. If there are two causes, one force majeure, one not, force majeure cannot be relied upon. Another important issue to look out for in the context of causation is whether or not under the contract or in practice the party claiming force majeure could actually perform, but by a different method than the one they intended. So, imagine a scenario where a party is allowed to take delivery of goods at a number of different ports under the contract. He would prefer to, or probably even planned, to take it at a specific port that's affected by, let's say, a flood. Now, can he claim force majeure? Well, the answer is no, not if the flood does not prevent him from taking delivery at some other port that hasn't been affected by a flood. He may need to rearrange things, but it's not force majeure. But in contrast, if a seller has enough goods to meet only some of his contracts, but not all of them, due to a force majeure event, say, preventing supply of raw materials, he may be able to rely upon force majeure for the contracts he cannot fulfil, even though he has chosen to perform some of the other contracts. The third limb of the test, and is rather obvious, but the party claiming force majeure must not be responsible for the event. The event must be beyond his control. So, if a company making widgets claims it can't deliver by reason of worker strike delaying production in its factory, it can't rely upon force majeure if the strike was caused by its own poor handling of the labour dispute. The fourth and final limb of the test is that the party claiming force majeure must take reasonable steps to try to avoid or mitigate its effects. So, in a case that I did, if a force majeure event is the absence of a government licence to do some work, and if the party claiming could have used reasonable efforts to get that licence, then there's no force majeure. He would have to show that the licence would inevitably have been refused if he had tried. But the point is, you have to go out and try and overcome the force majeure event. Now, in working out what reasonable steps are, the party has to take into account his counterparty's interest in receiving contractual performance. It can't be entirely selfish. He is entitled to take into account his own economic interests, so he's not required to do work or take steps that are costly and futile in the context of his business. But the fact that the steps are merely expensive or uneconomic or not particularly in his business interests is not a reason not to do them if they can avoid the force majeure event. What are the consequences of a declaration of force majeure? Well, it's for the parties to specify in their contract. Things that they might say. Firstly, it gives the party the right to suspend performance, for example, the obligation to deliver or the obligation to pay. Secondly, it might give a right to one party to cancel the contract entirely. The parties may decide that they want to oblige the parties to renegotiate the contract or the performance obligation. Or finally, they might just say, well, there's no liability for failure to perform in that case, and the contract just carries on. Something to bear in mind is that force majeure clause will often contain notice requirements that have to be complied with before force majeure can be relied upon. You have to read the clause and see what procedures need to be followed. Depending upon the exact wording, it may be the case that if you don't comply with the provisions, such as giving notice of the force majeure event within a specified time, then your right to claim force majeure is barred entirely. So you need to read that clause. So, to sum up, when looking for force majeure, the first thing you need to do is read the clause and see what it says. But it's likely you're going to need to identify four things. Firstly, whether there's a force majeure event. Secondly, has it prevented or hindered performance? Thirdly, is non-performance due to circumstances beyond the party's control? And fourthly, has that party made reasonable efforts to get around it? Thank you very much for watching, and I hope that's answered the question of what is force majeure.